Commissioners for Her Majesty's Revenue and Customs, Appellant, and Staff Superannuation Scheme Trustees Limited, Respondent.
Lord Briggs will explain the decision of the Court.
The question in this appeal is whether the UK regime for the taxation of manufactured overseas dividends falls foul of the European Union prohibition upon restrictions on the free movement of capital, which applied to the UK before its departure from the EU. The question arises in the context of what is called stock lending. This is a process by which the owner of a portfolio of shares may derive a little extra income from the shares in addition to the usual stream of dividends by lending them to a borrower which wishes to put them to one or more uses, such as meeting short positions or dividend arbitrage, which the lender would not wish to undertake on its own account. The standard terms of a stock loan are that the lender transfers the shares to the borrower against the borrower's promise to return equivalent shares at an agreed date in the future, and meanwhile to make payments equivalent to the dividends which the lender would have received if it had retained the shares during the period of the loan. For all this, the lender receives, in addition, a modest lending fee. These payments equivalent to dividends are called manufactured dividends, when the shares are held in a UK company, and manufactured overseas dividends, which I'll call MODs, when the shares are held in an overseas company. Dividends paid by overseas companies are typically subject to payment of withholding tax in the country where the company is based. Generally speaking, UK taxpayers receive tax credits in respect of withholding tax paid on their foreign share dividends to avoid double taxation. These credits can be set against appropriate UK tax liabilities. In order to ensure that MODs receive the same tax treatment as the overseas dividends which they replaced during the period of a stock loan, the UK imposed a deemed withholding tax on the borrower under the stock loan, which I will call the MOD withholding tax, and provided an equivalent tax credit to the lender. Article 63 of the European Treaty prohibits differential treatment, including tax treatment, of shares in UK and foreign companies if their effect is to disincentivize the acquisition of foreign shares as against UK shares. But Article 63 has never applied to differential treatment which is the result of the imposition of withholding tax. Double taxation is just treated as an unfortunate fact of life, arising from the basic right of member states within the EU to decide upon their own taxes. UK pension funds are largely tax-free. The result is that they pay no tax upon dividend income from UK shares, but they nonetheless suffer withholding tax upon dividends from foreign shares. And the tax credit which they receive in respect of foreign withholding tax is of no use to them because they have no tax liability of their own against which to offset the credit. They therefore face a significant tax disincentive in investing in foreign shares as against UK shares. But this is not itself contrary to Article 63. It is just an unfortunate fact of life. The question on this appeal is whether nonetheless the deemed withholding tax which the revenue levies on manufactured overseas dividends when the pension trustee lends its foreign shares to a UK borrower is itself a disincentive against the investment in foreign shares by a tax-free pension fund, separately from the disincentive already caused by the withholding tax which it suffers when it does not engage in stock lending. It is not a true withholding tax payable to another member state, but only a deemed withholding tax payable to the UK revenue. So it falls outside the fact of life exception from Article 63. The pension trustee pays no tax on manufactured dividends generated by lending its UK shares, but it says that it suffers the tax consequences of the MOD withholding tax because, although it's payable by the borrower, it receives only the net amount less the withholding tax and cannot make any use of the corresponding tax credit. The present claim was brought as a test case by the trustee of the Staff Superannuation Scheme, a tax-exempt pension fund. The claim was to the full repayment of all the MOD withholding tax paid in connection with foreign shares which it stock lent during the period of when the relevant UK tax regime was in force. Its own claim is for about £8.8 million, but the potential claims for which it is a test case would have exposed the revenue to a repayment liability in excess of £600 million if the claim had been well founded. The first-tier tribunal rejected the trustees' claim. It found that there was no relevant disincentive in the mod tax regime which contravened Article 63. The upper tribunal took the opposite view, holding that the difference in the relevant tax regime from the perspective of a tax-exempt pension fund between no tax on manufactured dividends from UK shares and the deemed withholding tax on mods was sufficient on its own to fall foul of Article 63. The Court of Appeal agreed, but on the much narrower ground that, but for the mod withholding tax, the tax-exempt stock lender might have been able to negotiate a slightly higher mod payment from its borrower in cases where the borrower planned to use the borrowed shares for dividend arbitrage, so as to increase its own net dividend income from the shares. This court unanimously allows the Revenue's appeal and restores the decision of the first-tier tribunal. Lord Sales and I give a joint judgment with which Lord Reid, Lord Hodge and Lord Hamblin all agree. Our reasoning is, in brief summary, as follows. The starting point is to recognise that the whole commercial purpose of the mod in the typical stock lending agreement was to create an income stream in the hands of the lender exactly equivalent to the net dividends which would have been received by the lender if it had retained rather than lent the stock. The additional benefit to be derived from stock lending lay in the lending fee rather than any enhancement of the dividend stream. Thus, the question raised by Article 63 is whether, but for the mod withholding tax, the borrower would have been prepared to pay a higher stock lending fee. In a sophisticated market, it was to be assumed that the prospects of benefit to the lender from engaging in dividend arbitrage were already built into the agreed lending fee. Critically, it was no more than mere speculation to think that, but for the mod withholding tax, the borrower would have been prepared to increase that fee. This was in particular because, although it was the borrower's liability to account to the revenue for the mod withholding tax, this caused it no economic burden because the typical stock borrower generally had sufficient of its own tax credits to set off against the whole of the mod withholding tax. Had we taken the view that there was an infringement of Article 63, along the lines adopted by the Court of Appeal, we would nonetheless have been of the view that the trustee was not entitled to a repayment remedy and would for that reason have dismissed the appeal. This was, in short, first, because the revenue did not in substance receive the withholding tax for which the applicable mod tax regime provided a useless tax credit to the trustee. That was on account of foreign withholding tax received by other member states. Secondly, on the analysis of the very modest dissuasive effect identified by the Court of Appeal, a repayment remedy would have been wholly disproportionate. No lesser or more proportionate remedy had ever been claimed. The appeal is therefore allowed.
Crown on the application of Coughlin, Appellant, and Minister for the Cabinet Office, Respondent.
Lord Stevens will explain the decision of the court.
This is an important case concerning whether the Minister for the Cabinet Office was acting within his legal powers when making 10 separate orders by way of subordinate legislation, authorising pilot schemes to temporarily change the rules governing local government elections. The 10 orders applied to 10 separate local authority areas, and they were implemented in those areas in the local government elections in May 2019. Each of the orders introduced a new requirement for voter identification so that, as a precondition to casting a vote, a person was required to produce one of several specified documents, such as a driving licence or a passport. The appellant, Mr. Neil Coughlin, lives within the Baintree District Council area, which was one of the 10 local authority areas subject to a pilot scheme requiring voter identification. The appellant believes that voter identification requirements in elections present a significant barrier to democratic participation, including because the poor and/or the vulnerable members of the community are less likely to be able to produce identification, such as a driving licence or a passport. The court is not concerned with the merits of the decision to introduce these pilot schemes or with the merits of voter identification schemes in general, but only with whether the Minister for the Cabinet Office had the power to make the 10 orders. The legal power of the Minister to make the orders authorising pilot schemes is contained in Section 10 of the Representation of the People Act 2000, which is titled Pilot Schemes for Local Elections in England and Wales. Section 10, subsection 1, enables the Minister for the Cabinet Office, by subordinate legislation, to make such provision for and in connection with the implementation of a scheme as he considers appropriate. However, that power to make subordinate legislation is limited to a scheme within the meaning of Section 10, subsection 2. For present purposes, the relevant provision is Section 10, subsection 2, paragraph A, which provides for schemes as regards how voting at the elections is to take place. The appellant brought proceedings challenging the lawfulness of the 10 orders on 2 grounds. First, the appellant contended that the 10 orders were outside the powers of the Minister for the Cabinet Office because the pilot schemes they sought to establish were not schemes within the meaning of Section 10, subsection 2A, as they were not schemes as regards how voting at the elections is to take place. The appellant submitted that the phrase, how voting at elections is to take place, is confined to the actual mechanics of voting, such as whether votes are to be cast in person, by post, over the telephone, or online, and that it does not include establishing eligibility or entitlement to vote by producing identification. Second, the appellant contended that the pilot schemes were not authorised for a lawful purpose under Section 10, subsection 1 of the Representation of the People Act 2000, consistent with the policy of that Act. It was submitted that the policy of the Act was confined to facilitating or encouraging voting at elections, and that voting identification requirements did not facilitate or encourage voting. The appellant's challenge was dismissed in the High Court and by the Court of Appeal. He now appeals to the Supreme Court, which unanimously dismisses his appeal for the reasons set out in a judgment given by me, with which the other justices agree. In relation to the appellant's first ground of challenge, the Court concludes, based on an analysis of the language used by Parliament, that the phrase, how voting at the elections is to take place, is sufficiently broad to encompass procedures for demonstrating an entitlement to vote, and is not confined to the mechanics of voting, such as whether a vote is cast in person or by post. For instance, Section 10, subsection 2 provides that a scheme under Section 10, subsection 1 is a scheme which makes provision differing in any respect from that made under or by virtue of the Representation of the People Acts. That is liberal, permissive language that supports a wider meaning for the word how, where it appears in Section 10, subsection 2, paragraph A. Another instance is that pilot schemes for internet voting would be within the phrase, how voting at the elections is to take place. And it is obvious that such pilot schemes must have a voter identification requirement to be effective. Accordingly, the appellant's first ground of challenge is dismissed. In relation to the appellant's second ground of challenge, the Minister could not lawfully make the 10 orders if they defeated or ran counter to the policy and objects of Section 10 of the Representation of the People Act 2000. However, the appellant is incorrect that the policy and object of the Act is confined to facilitating and encouraging voting. Rather, the policy of the Act is to enable pilot schemes to temporarily modify the existing arrangements in relation to particular local government elections so as to permit evidence to be gathered as to the effect of such changes at real elections and for that evidence to be assessed, including by the Electoral Commission. The policy includes authorising schemes that could have adverse effects on the exercise of the right to vote, because they are, despite their effects, a valuable way of obtaining information about potential reforms to electoral law and procedure. Accordingly, the 10 orders did not defeat or run counter to the policy of the Act, and the appellant's second ground of challenge is dismissed. Overall, as I have indicated, the appeal is dismissed.
The court will now adjourn.